I hear you.
All right. The Rules Committee will come to order. Today, this committee will be considering three measures. The first is S.J.Res 7, which would finally end U.S. involvement in the Saudi-led conflict in Yemen. It has been going on for more than 4 years, resulting in a humanitarian catastrophe. 22 million people in need of humanitarian assistance. 85,000 children under the age of 5 have died of hunger and disease, and the largest food emergency in the world. This is a war by any measure, but one that was never authorized by the legislative branch. Prior Congresses ceded that responsibility to the executive branch instead. Past Republican Congresses even used every legislative trick in the book to prevent so much as a debate on our role there. They even took the unprecedented step of stripping war powers resolutions related to Yemen of their privilege, not once but twice. But this complacency is coming to an end. This resolution is virtually identical to the version the House passed earlier this year, and it passed the Senate with a strong bipartisan vote. This is our first chance to send a measure relating to Yemen directly to the President, and I'm hopeful that we will get this done. Second, we will consider H.Res 271, condemning the President's crusade to take away Americans' health care. Republicans weren't successful getting rid of the Affordable Care Act legislatively, so now they are trying to get it overturned in the courts. That would cause premiums to skyrocket, allow insurance companies to deny coverage because of pre-existing conditions, and lead to millions of Americans losing health insurance altogether. This majority took action on day one of this Congress, allowing the full weight of the House to be brought to bear in Texas versus U.S., and we are taking action again as the President doubles down on trying to take away health care from people, and even without an alternative plan. So I hope my friends on the other side of the aisle would join us in this. Third, this committee will consider H.R. 1585 to reauthorize the Violence Against Women Act. The co-author of the original law is the former chairwoman of this committee, Congresswoman Louise Slaughter, whose portrait hangs in this room. This year is the 25th anniversary of this landmark law, which fundamentally changed how our nation confronts the scourge of domestic violence. It encouraged survivors to step out of the shadows and help give them the resources they need. More than 1 million people participated in a service provided by VAWA funding over a recent 2-year period. These are life-changing and, in some cases, life-saving resources. I'm proud to see us taking action to reauthorize this law and carrying on Louise's fight in support of VAWA. Before we hear from our witnesses, let me turn to the ranking member, Mr. Cole, for any remarks he would like to make.
Thank you very much, Mr. Chairman. If I may, before I go into my prepared remarks, I'd like to submit for the record the administration's position on SJ7.
Without objection.
Thank you very much, Mr. Chairman. We're here today to consider three very different pieces of legislation, the most important of which, in my view, is the reauthorization of the Violence Against Women Act. As many of you know, VAWA is near and dear to my heart, and it's of great importance to the people of Oklahoma, and particularly to tribal communities, including my own tribe, the Chickasaw Nation. I don't think the reauthorization of VAWA should be used as a tool that one political party uses to score partisan points, like we're seeing here, and sadly, in my opinion, today. Rather, it should provide an opportunity for Republicans and Democrats to come together and pass a reauthorization that has broad-based bipartisan support and could expeditiously become law. Frankly, it's very disappointing to me that we're even here today to deal with this issue. I've been openly supportive of a clean reauthorization for months for numerous reasons, not the least of which is providing Native American tribes with the tools that they need to keep their female constituents safe. With every reauthorization of VAWA comes the opportunity to improve the underlying statute. Fortunately, this bill reveals several missed opportunities to improve the law, and there are provisions in this bill that are, again, unnecessarily partisan and will cause division. However, reauthorization of VAWA, in my view, is too critical and far too long past due for me to oppose the version before us here today. However, I certainly hope it changes in the course of consideration, because I don't think the bill we have will ever be passed by the United States Senate. And it's important that we get something done. I do expect my Republican colleagues to share more in depth about their concerns in the hopes that we can resolve these issues prior to the Senate consideration of H.R. 1585, because again, in my view, Mr. Chairman, if the bill doesn't change, it's not going to get through the United States Senate or be signed by the President. We're also meeting here today on two additional pieces of legislation. I've made my views on the Yemen situation clear during our previous hearing on that topic. Suffice it to say, I'll continue to oppose this legislation for the same reasons I outlined then. Finally, we're considering yet another non-binding resolution, this time on health care, that reflects nothing more than an attempt to score some political points. A few weeks ago, I asked my Democratic friends in the majority to work together on bipartisan legislation that would actually address real and pressing problems facing our country. I had hoped that would lead to a resolution, but instead, the Democratic majority has again chosen to bring up a resolution that will have absolutely no impact whatsoever. No law will be passed, no statute will change, and the text will have no effect at all on the American people. Today, I'd like to ask the majority to do something radical, take yes for an answer. Republicans are ready and willing to pass real legislation that protects people with pre-existing conditions. We've consistently supported ensuring those with pre-existing conditions still have access to affordable health care. 2017, as part of our replacement for Obamacare, we included legislation that would have preserved access for those with pre-existing conditions. At the beginning of this Congress, on day one, in fact, Republicans offered a motion directing the House to produce legislation that would lock in protections for pre-existing conditions. Specifically, the legislation would have to guarantee no American citizen can be denied health insurance coverage as a result of previous illness or health status, and guarantee no American citizen can be charged higher premiums or cost sharing as a result of a previous illness or health status, thus ensuring affordable health coverage for those with pre-existing conditions. Democrats chose to block the motion then, but they have an opportunity to do something real now, and we remain ready to work with them in a bipartisan fashion. Mr. Chairman, we can do better, and we can do better than these bills we are considering today. I hope in the future going forward we will. Well, thank you, Mr. Chairman.
Thank you very much. And the gentleman yields back. And let me just say that nobody here is suggesting that the Affordable Care Act is perfect, and we have been willing to work in a bipartisan way to try to expand health care protections. I mean, we're doing this today because, quite frankly, the President seems to have doubled down in trying to just repeal the entire Affordable Care Act outright and not coming to Congress with ideas or changes. He's going to the courts, trying to just null and void it. And so, I would hope my colleagues on the other side of the aisle would reject the President's approach by going to the courts, and instead, let's sit down and talk about, areas of commonality where we can move forward, and I hope we can get to that point. But before we move on to the testimony, I want to yield to the gentleman from Florida, Mr. Hastings, for a housekeeping item.
Thank you very much, Mr. Chairman. Mr. Chairman, I ask unanimous consent that members serve on the subcommittees of the Committee on Rules as follows. The Subcommittee on Legislative and Budget Process, myself as chair, Mr. Morelli as vice chair, Ms. Scanlon, Ms. Shalala, Mr. McGovern, Mr. Woodall as ranking member, and Mr. Burgess. The Subcommittee on Rules and Organization of the House, Mrs. Torres as chair, Mr. Perlmutter as vice chair, Ms. Scanlon, Mr. Morelli, Mr. McGovern, Ms. Lesko, and ranking member Ms. Lesko as ranking member, and Mr. Woodall. The Subcommittee on Expedited Procedures, Mr. Raskin as chair, Ms. Shalala as vice chair, Ms. Torres, Mr. Desaulnier. I have trouble with
Your
that.
French never sounded better.
I tell you. Mr. McGovern, Mr. Burgess as ranking member, and Ms. Lesko.
Without objection, so ordered. So thank you. We are considering three bills today, and first up, we will take testimony regarding S.J.Res 7, directing the removal of United States Armed Forces from hostilities in the Republic of Yemen that have not been authorized by Congress. Mr. Malinowski and Ranking Member Mr. McCall, we're delighted to have you here. and anything you brought in writing will, without objection, be entered into the record. And this is kind of a repeat of what we just talked about a few weeks ago, but because we altered the bill in the House, it lost its privileges in the Senate, so we're back. So hopefully this time this will be the last time we have to do this. So, Mr. Malinowski.
Thank you, Mr. Chairman, Ranking Member Cole, members of the committee. I'm grateful for the opportunity to be here as a member of the Foreign Affairs Committee and a strong supporter of this measure to end our involvement, our military involvement in the Saudi-led war in Yemen. As you mentioned, we've been through this before, so there are no surprises in this resolution. We're probably not going to hear too much new in the debate because it has already passed both houses of Congress with bipartisan majorities. It's already passed the Senate twice. We're here because of procedural moves that have been taken to try to slow it down or derail the process. As you know, at the heart of this resolution is putting a stop to American aerial refueling of Saudi and Emirati coalition planes making attack runs in Yemen. And if anyone isn't clear, there have been way too many instances over the years when these planes have dropped their bombs on innocent men, women, and children, on weddings and funerals, on school buses, on roads and bridges vital to the delivery of humanitarian aid. I know something about this because when I was a State Department official, I was actually in charge of our efforts to try to counsel the Saudis on better ways of conducting this war. Members of my team sat with Saudi military officials to try to guide them in better use of the equipment that we had given them precisely for the purpose of reducing civilian casualties. And we tried again and again and again, and we concluded that we failed, that there was absolutely no change in the manner in which the Saudis were conducting this war. In fact, in many cases, they were deliberately striking targets that we had put on a no-strike list and asked them not to strike. And so that's why I believe this is the only resort that we have left. Now, because we've been through this, we've heard the arguments against it quite a few times. One says that this resolution would jeopardize our security cooperation arrangements with other countries around the world. That's not true. The text of the resolution makes clear it only applies to the ongoing civil war in Yemen, and even there it does not apply to operations against al-Qaeda and associated forces. It would not affect our security cooperation anywhere else in the world. A second argument is that the Pentagon has already ended aerial refueling in Yemen, and that's true, but it's a matter of policy. The President could snap his fingers, fire off a morning tweet, the practice could resume immediately. This measure would end it as a matter of law. A third argument says that the Pentagon has determined that we are not engaged in hostilities against Houthis in Yemen, which is the standard required under the War Powers Act for this sort of resolution. I'm not sure if the State Department lawyers would agree. They would not have in the period when I served. I'm certainly prepared to make the case if anybody asks that we are, in fact, engaged in hostilities in Yemen, that refueling is a classic example of that, but we could come back to that if members have any questions. Mr. Chairman, the United States Constitution ultimately does not grant war powers to the administration or to the Defense Department. Only Congress can say what constitutes war and how to exercise constitutionally granted war powers. Except in very limited circumstances, only the Congress decides when and where the United States can enter a war around the world. For too long, we have given away that authority. With this measure, we're taking the first step in reclaiming it. And we're not just flexing our muscle because we can, we're doing so because the world has seen the horror of what is taking place in Yemen, and it is time to take a stand. When we allow the United States to be complicit in the murder of innocent children, in a war that 2 administrations have tried to stop, and yet we continue our own involvement in it, fueling the world's worst humanitarian crisis, cholera, starvation, then we've betrayed everything our country stands for. It's an abdication of what American leadership should be on the global stage, leadership that stands up for the rights and dignity of all people, that puts our values at the center of what we do. So I'm glad to be here today, Mr. Chairman, and make the case for why, once again, the House needs to consider and pass this resolution without delay. Thank you again. I'm glad to take any questions you may have.
Thank you very much, Ms. McCall. Welcome back.
Yeah, it's kind of a feeling of deja vu. We were here about 7 weeks ago, and I want to thank you, sir, and Ranking Member Cole. We had an extended discussion about this with House Resolution 37, really identical to this measure that we're looking at today. The approach remains problematic in my judgment because it tries to use war powers mechanisms where we are simply not at war. It directs the removal of U.S. troops from hostilities where there are no U.S. forces to remove. As the Department of Defense has repeatedly confirmed, no U.S. United States forces are conducting hostilities against the Houthis in Yemen. This resolution is abusing a war powers mechanism to get at a completely different security assistance issue, which Congress already has clear tools to address. This resolution does nothing to address the humanitarian crisis that my colleague mentioned in Yemen. It does nothing to secure justice for the heinous murder of Jamal Khashoggi. It does not even merit a real discussion on U.S. security assistance to Saudi Arabia. The only thing it addresses clearly is mid-air refueling of coalition aircraft, which ended in November of 2018 and is not in danger of restarting. This resolution stretches the definition of hostilities to cover non-U.S. military operations by other countries. It reinterprets U.S. support to those countries as engagements in hostility. This has implications far beyond Saudi Arabia. This precedent will empower any single member to misuse privileged war powers procedures to force a prompt and repeated congressional referendum that could disrupt U.S. security cooperation agreements with more than 100 countries around the world. And at a time when we're an even closer partner than Saudi Arabia, that is Israel, is moving to protect itself against rocket attacks from Gaza, I think it's a dangerous precedent to legitimize this abusive process. Finally, this resolution completely ignores the malign influence of Iran. It refuses to recognize the continuing responsibility of the Houthi insurgents for violently overthrowing the government of Yemen, for provoking and perpetuating this humanitarian disaster, and for their rampant abuse of human rights. This one-sided approach will weaken the hand of the UN Special Envoy to Yemen, whose efforts currently represent the best hope that we have of bringing a negotiated, peaceful end to this conflict and ending the suffering of the people of Yemen. For these reasons, I oppose this resolution, and I yield back.
Well, thank you very much, and I appreciate both of you, both of your testimony. I mean, I obviously strongly support this. I'm horrified by what's happening in Yemen, and I've been equally disappointed in the lack of U.S. response to this horrific violation of human rights that is being imposed on the people of Yemen. So we could re-wage the debate we had a few weeks ago, but you could replay the tape. So I don't have any questions, Mr. Hastings.
I have no questions.
Mr. Cole.
Just a couple of quick ones. Who was President of the United States when this operation by Saudi Arabia began?
President Obama.
And was the United States government supportive of this operation?
Yes.
And we were regularly doing refueling in that time period, is that correct?
No, that's correct.
Which president canceled that?
No, the current President Trump.
Okay. Again, I would suggest to my friends, this began as American policy supporting an ally in a matter where they felt they had, and we felt they had, national security interests at stake. And I particularly appreciate my friend's point about the failure to mention the Iranians and the Houthis, who are on the other side of this and have shown, at least to my knowledge, no willingness to pull back or sit down and actually have a dialogue that would end the conflict. Is that correct, as far as you know?
I see this resolution. I said it on the House floor. What worries me the most is it emboldens the Iranian proxy, the Houthis, in that part, in Yemen. And We actually saw that in reaction to the last time we were on the floor discussing this. So, if anything, I see this as helping one of the largest state sponsors of terror, and that is Iran, and their efforts to overthrow the government in Yemen by their proxy, the Houthis.
Thank you, Mr. Chairman. I won't go through the debate again, but I thought those were important points just to reiterate. That yield back my time.
Yeah, no, I appreciate that, but I'm also worried about emboldening Saudi Arabia and their horrific record on human rights, because we want to go down which administration turned a blind eye to the murder and dismemberment of a Washington Post journalist. It's this administration. There are no real consequences on Saudi Arabia for any of their human rights violations against their own people, and certainly no accountability as this war in Yemen has gotten out of control. So, in any event, Ms. Torres?
May I respond? I strongly condemned the execution of Khashoggi as well.
I'm talking about the administration. I mean,
this
administration has the silence on this, what has been going on, has been deafening. And I will tell you that that does more to undercut our standing in the world when it looks like we're not on the side of human rights, that we're transactional, that it's a relationship where we get oil or whatever, and we're not, and we want to sell more weapons to them, so we don't say anything. I mean, that's a lot of this concern that we have is that this ally of ours, when it comes to human rights, is going in the wrong direction.
Then, sir, I would suggest we have a resolution condemning the murder of Khashoggi, but this resolution has nothing to do with that.
I'm happy to join with you on that as well.
Yeah.
Yeah. Look, I'm not here to argue about which administration was better or worse on Saudi Arabia. Every administration has gone down this path with the Saudis. And Mr. Cole, you're absolutely correct. And I was part of the Obama administration when we made the decision to support them in Yemen, partly because we have a close partner relationship and because we were concerned about what Iran was doing. The thing is that we saw fairly quickly that the way in which they were conducting the war was helping Iran. Iran is investing a tiny bit of money in support for the Houthis in order to induce the Saudis to do things that are entirely self-destructive. Civilian casualties, famine, cholera, these things are absolutely in the interest of Iran to happen, and it is the Saudi campaign that is causing them. So years of learning this lesson has led many of us to conclude that continued support for the Saudi war is not in our interest, not in Saudi Arabia's interest, very much in Iran's interest, and that's why we want to stop it. So, again, this is not meant to be partisan. This is about what's best for us.
And thank you. And I said I wasn't going to get into this because we did this a couple of weeks ago, so I'm going to shut up. Ms. Torres, yeah.
Yeah, I just simply want to say I'm proud to support this measure, and yield back.
Thank you. Mr. Burgess.
Thank you. Let me just ask a question for my own clarification. The prohibition on aerial refueling. This resolution passes, that's an absolute prohibition?
Yes.
And if there were...
It carves out the al-Qaeda.
So if there
conflict.
were a condition where United States personnel were endangered, either diplomatic or military personnel, that prohibition on aerial refueling would be suspended?
No.
There's absolutely an absolute right to self-defense for our armed forces under any circumstances. The war powers, any war powers resolution would not preclude our forces from defending themselves in any context.
I tend to see it a little different interpretation. If I could refer to... Yeah, it says removed from hostilities and including in-flight refueling of non-U.S. aircraft conducting missions as part of the ongoing civil war in Yemen. So that's the way the resolution reads.
The protection of our own personnel, our own personnel.
I think it would prohibit. My interpretation, I'm an attorney, is that it would prohibit that.
It would prohibit that.
Mm-hmm.
I can't really imagine a circumstance where our forces, we have no forces, I mean, where we would be precluded from we're not involved in Yemen in a way where that would even be relevant. In other words, what we're doing is we're supporting offensive Saudi operations against Houthi targets in Yemen. If there were ever a circumstance in which American forces anywhere in the world were in imminent danger of attack, we always retain the right to defend ourselves. There's nothing in a war powers resolution that would preclude that.
Thanks for the clarification. I mean, the statement was made that the president could, on his own whim, after a tweet, decide that he was going to do something different. And if it was required to protect United States diplomatic personnel or military personnel, I hope he would.
And I would hope so too. And again, nothing here precludes that.
But Mr. McCall, you don't agree that this would preclude that?
I think the only thing, this is what I mean, to me, it's nonsensical. We're calling for withdrawal of U.S. forces in Yemen, working with the Saudis, when in fact that's fiction. We do not have combat forces in the conflict zone in Yemen. So the whole premise of this resolution, to me, doesn't make a whole lot of sense. And the one thing they point to is this refueling argument, when in fact our president today has stopped that. If this resolution passes, I would argue that it would put that in jeopardy if we wanted that to be an option in the future.
Well, I thank you both for the clarification. I'll yield back, Mr. Chairman.
And I know I wasn't going to say anything, but I don't think there's anything in here that would prevent the president from starting up again the refueling.
Yeah.
Mr. Raskin?
Thank you both for your testimony and your hard work on this. It just seems to me that if the Crown Prince of Saudi Arabia is willing to kidnap a journalist for the Washington Post and have him bound and gagged and drawn and quartered and dismembered and disposed of, what would that same government be willing to do to helpless children in Yemen? And we don't really need to imagine it because we have the record of what's taking place with the terrible civilian casualties there. So I'm very much in support of this, and I guess my only question to you, Mr. Malinowski, is have there been any changes in the Saudi government's conduct since the world has castigated MBS for the murder of Mr. Khashoggi?
There has not been a change that I can discern in the way in which they've conducted the air war in Yemen. And that is despite not just condemnation, but despite American officials, military and State Department officials, sitting with them in their war room, going over in extreme detail, month after month after month, policies and procedures to protect civilians on the ground. And in many cases, not just generalized policies, but handing them lists of targets not to strike. Do not hit this bridge. Do not hit that warehouse. Usually these were targets that were related to humanitarian deliveries in Yemen, and then seeing the Saudis strike those targets, the precise targets that we've given them a list of. So wow. Even if one does not take a moralistic position with respect to Saudi Arabia, the mere fact that they have refused to take our advice is enough for me to say enough is enough.
And I've condemned, and we have another dual citizen that's in prison being tortured. I think, that's a moral issue. I don't think it's not related to this resolution, though, is my point. And if anything, the assistance with targeting I would argue, has saved casualties and innocent civilians.
Okay, I yield back, Mr. Chair. Thank you.
Ms. Lesko.
Thank you, Mr. Chair. Seeing that we already debated this or similar a couple of weeks ago, I don't have any questions, but I do want to point out I'm still opposed to it for the same reasons that Mr. McCall had said. And also, this one doesn't include the provision against anti-Semitism either, like the one that passed the House.
Ms. Scanlon.
Thank you. Yes, I support passage of this resolution. My understanding is we can't include that resolution because it then wouldn't be a Clinton bill. But we have already passed another resolution condemning anti-Semitism and other isms. So
Absolutely.
let's move forward.
Mr. Morelli? Ms. Shalala?
I support the resolution for the children of Yemen, who have literally thousands and thousands of them, 85,000 according to projections, have died from hunger and disease. This is the least we can do.
Thank you. Mr. Saunier? No? Well, thank you very much for being here. We'll see you
Thank
on
you,
the floor.
Mr. Chairman.
All right, all the best. So that ends the hearing on S.J.Res 7. Now we will consider House H.Res 271, condemning the Trump administration's legal campaign to take away Americans' health care. And we, so we have the Honorable G.K. Butterfield and the Honorable Larry Bouchon. Okay. All right, Mr. Butterfield. Yeah, Mr. Butterfield, you can begin.
Thank you, Mr. Chairman. Ranking Member Cole, thank you for the opportunity to come this afternoon and make this presentation to you. I hope each of you had a productive weekend, and welcome back to the Hill. Today, Mr. Chairman, I am appearing on behalf of my Democratic colleagues on the House Energy and Commerce Committee and in my capacity as Vice Chair of the Subcommittee on Health. Mr. Chairman, I support Congressman Colin Allred of Texas and his resolution, House Res 271, which is a resolution to instruct the U.S. Department of Justice to reverse its position in the Texas versus U.S. decision. As we all know, that decision was handed down in the Northern District of Texas by Judge Reed O'Connor. Mr. Chairman, 271 is critical to the protection of the Affordable Care Act. It is also an important resolution to uphold legal precedent that the Trump administration seems to consistently disregard. On 7 June 2018, the Department of Justice announced that it would not defend the constitutionality of the Texas versus U.S. case, breaking with generations of legal precedent and undermining our system of justice. On 25 March of this year, the Department of Justice announced that the entire ruling of the district court should be upheld and the entire ACA should be declared unconstitutional. We were very surprised about that. The effect, excuse me, Mr. Chairman, the effect of the Texas versus U.S. decision, if upheld, would strip health care coverage and protections for 21 million Americans. If the ACA is struck down, protections for 130 million Americans with pre-existing conditions will disappear. The uninsured rate in our country will increase by 65%. The Texas case, Mr. Chairman, if upheld, would also end Medicaid expansion as we know it, stripping health coverage for more than 17 million people. My home state of North Carolina and our governor are currently working to expand Medicaid. Doing so would provide coverage to nearly 500,000 low-income citizens. More than 300,000 of those residents have no other insurance options available to them. This resolution will protect those currently covered through Medicaid expansion and will enable states like my state and many of your states to continue to enable more of their residents to become insured. I can go on and on about the administration and the Republican effort to repeal the ACA. We all know that quite well. More than 12 million seniors will have to pay more for prescription drugs. More than 2 million children will no longer be able to stay on their parents' insurance. And so I am disappointed that the Trump administration is threatening to strip health care from millions of Americans. The President and the Republican minority are truly the anti-health care party, which is contrary to many of their stated positions. This resolution will help defend the ACA from their misguided attacks on the middle class and their health care. Thank you very much, Mr. Chairman, for the opportunity to make these remarks.
Mr. Bouchon, welcome.
Thank you, Mr. Chairman. The resolution before the Rules Committee today is nothing but political theater. And as a physician, honestly, I'm personally insulted by the premise. On the opening day of the 116th Congress, House Republicans brought a simple and powerful measure to the floor that called on lawmakers to legislate on what we all agree needs to be done, locking in protections for patients with pre-existing conditions. Unfortunately, in a fit of bipartisanship, House Democrats blocked the effort. If Democrats were serious, they would make
they would immediately take up legislation to protect patients with pre-existing conditions. If they're seriously concerned about the outcome of Texas v. United States, they could vote to moot the lawsuit by repealing the individual mandate or reinstating the individual mandate penalty. After all, Democrats wrote the ACA, but I don't see any legislation being offered. But instead of legislating to lock in pre-existing condition protections or legislating to moot the lawsuit, Democrats are trying to score more political points. Republicans stand ready to protect those with pre-existing conditions in a manner that will withstand judicial scrutiny. Ultimately, Democrats don't want to talk about, in my opinion, their real health care agenda, Medicare for All. Medicare for All is a government-run, single-payer, socialized medicine scheme. It'll cost the taxpayers $32 trillion, requiring massive tax increases in order to pay for it. It ends employer-sponsored health care, forcing 158 million Americans who get their health care through their job or unions into a one-size-fits-all government plan. It ends Medicare as we know it by doing away with a Medicare trust fund that seniors have paid into their entire lives. Republicans support a health care system that protects American citizens with pre-existing conditions, increases transparency and choice, and lowers costs across the country. Again, this resolution is political theater, and I can't support it. Thank you, Mr. Chairman.
Well, thank you very much. And let me just say, I mean, there are a variety of proposals out there to improve and reform our health care system. Medicare for All is one of them, and nobody's afraid to talk about it. We're going to do a hearing in this committee in the not-too-distant future, so we will have that conversation. I don't have any questions. Let me just ask one question, though, Mr. Bouchard. Do you believe that Medicare is a socialist program?
No.
Okay. Well, thank you. Well, I'm glad you clarified that, because why
Medicare only represents a small portion of the American health care system.
So is it socialism?
Medicare for All creates a system with no private sector competition, which essentially socializes the health care system as a whole.
When Medicare was being debated initially, we had many people, some in your party, referred to as a socialist program.
I was 3 at the time, so I mean, I wouldn't know, honestly.
But if you turn back the clock, and you look at what many Republicans were saying about Medicare for senior citizens at the time, it is very similar to what we're hearing today. But we'll talk about that, but that's not what this is about. The President has decided to go to the courts, not work with Congress. Mr. Cole has a point. If there needs to be improvements, we should work together. But that's not what the President is doing. He's going to the courts to null and void it, to create a catastrophe. And quite frankly, I think it's important that he hear loud and clear that the majority in this House of Representatives is dead set against what he's doing. Mr. Cole.
Thank you very much, Mr. Chairman. Just quickly, does this resolution have any practical effect whatsoever?
None.
President required to listen to it?
No.
Does it fund an effort by the Congress to have the other side in the courts?
No.
Then it's hard to see for me that it's anything other than a purely symbolic statement. And, that's a lot of time, floor time we seem to waste, just making theatrical statements because the whole world evidently seems to know what our opinion is about something. You have 20-odd states here. It's in court. I think they won the opening round. It's going to proceed. By the way, Mr. Chairman, in all fairness, I could make the same argument to the President. I mean, this is a court case that's just moving through the way it should. And so, whether we should, the courts will either find it's constitutional or it's not on the basis of the merits of the arguments. And to me, I fail to see the need to rush to, have this debate and waste time. But again, certainly nothing inappropriate if you want to bring a resolution
we think it's
forward.
important.
Well, I guess, because it has no effect. So you must think it's important some way because it has absolutely no impact. That's the only question I care to, or point I needed to make, Mr. Chairman.
Thank you very much. Mr. Hastings.
Mr. Bouchard, is social
Yes, sir.
security socialist program?
No.
Why?
Because the American people pay into it their entire lives, and it was put into law, as you know, many, many years ago, because at the time after the Great Depression, there were seniors who were destitute, who had no source of income at all. And so it's not a socialist, it's a safety net. It's a safety net program to prevent seniors from being destitute if they don't have any retirement savings.
How about Medicaid?
But they pay into it.
How about Medicaid?
No, it's not. It's a social safety net. Again, it's not the only health care out there. There is private sector competition. In fact, as you probably know, 80 or 90% of Medicaid today is managed by the private sector across the country, so it's not.
It's interesting to me how you all pick and choose this word socialism, and I just find it passing strange, that's all.
Mr. Burgess?
Thank you, Mr. Chairman. Whenever we have these kinds of arguments, I'm always reminded of our former colleague, Dr. Jim McDermott from Washington State, Democrat, and when Republicans would bring a sense of Congress resolution to the floor to reform the IRS. And he would get up to the podium and say, why don't you just send a get well card to the IRS? Because it would have the same effect. So that's kind of the way Mr. Bouchon is right in his observation. Mr. Cole is right in his observation. I think the lawsuit itself will settle an important point. The logic that was used by the Chief Justice to get around the problems inherent in the Commerce Clause when the Affordable Care Act was challenged by the National Federation of Independent Businessmen in 2012. I thought the law was going to be struck down on constitutional grounds, and I was surprised by the legal arguments that allowed it to stay in place. However, the individual mandate was flattened, and in the tax reform bill that was passed in December of 2017. So without that penalty imposed by the individual mandate, the question then was, does Justice Roberts' legal reasoning still hold up? I got to tell you, based on some other arguments that he made at the time, and he said, don't expect the judiciary to do something that the legislative branch should have done. I think he very likely still feels that way. You still have the same then 5 justices who voted in favor of continuing the Affordable Care Act, still will be when this case does get to the Supreme Court, but it will be an interesting legal theory that, that gets tested. I will say, and it is of concern to me, that we keep hearing that Republicans wouldn't do anything to try to mitigate some of the problems that everyone has identified in the Affordable Care Act, and that's just not true. Your staff director, when he was my legislative liaison to the Obama White House, we had multiple discussions on things that could be done differently. Look, I didn't like many of the things that were happening to my constituents because their premiums had gone up so much, their deductibles were so high. But look, if we're going to have a high deductible health plan, I had a high deductible health plan with a health savings account, so why don't we make bronze and silver level metal levels in the Affordable Care Act? Why don't we make them all HSA compliant without someone having to do some other maneuver to get to that point? Why don't we allow the amount of money that is incorporated in a health savings account, why don't we let that equal the deductible at the bronze or silver level? I've never understood when I had an HSA with under an unsubsidized ACA healthcare.gov policy, I could put away $3,400 a year, but my deductible is $68. So obviously that math doesn't work. I was willing to try to fix that. Never could really interest anyone in the Obama administration in pursuing that discussion. I would have also considered allowing individuals in the individual market to get the same break that people in the large group market do, that they could pay with after-tax dollars. We could have extended their ability to purchase insurance and extended the value of their dollar, but we, for whatever reason, would not do that. Now, I do think it's interesting when we talk about court challenges that are going to perhaps put people's health care in some sort of jeopardy. You know, the Trump administration, I think correctly, through the Department of Labor, had expanded the definition of an employer and allowed for the expansion of what are called association health plans. I like that concept. I would have happily entered into a relationship like that when I ran my medical practice, to be able to get insurance for my employees at a lower cost. As we discussed in our committee last week, association health plans or employer-sponsored insurance under the governed under ERISA statute, there's no exclusion or underwriting for pre-existing conditions in ERISA plans. And that's not the Affordable Care Act, that's ERISA law passed in the 1970s. So, yeah, there are some things that we could do, and I'm hopeful that we'll have the discussion. I am concerned that it always does seem to be there is only one way to do this, and that is either the Affordable Care Act or some sort of grandiose single-payer system. I'd like to see us incorporate association health plans. I'd like to see us expand health reimbursement accounts and give every person in the country the same type of break that members of Congress get when they get a tax-free subsidy to walk into a health insurance policy. I think that would be a wonderful discussion to have, but we never seem to get to have those discussions. But I appreciate most of our witnesses being here today. I know we're going to have a lot of discussion on Wednesday in our markup, so we'll continue this lively discussion that's been going on for several weeks. And as the gentleman from Washington used to say, yeah, get well quick, healthcare.
Thank you. And I just remind the gentleman that we've only been in charge of the House for 4 months, and I don't remember being asked to be part of any discussion in a bipartisan way about any Republican healthcare ideas that were brought before this committee. Anyway, Ms. Torres.
Thank you, Mr. Chairman. You know, once again, we're here dealing with Republican efforts to end the Affordable Care Act, which has provided health care insurance for more than 5 million people in my district who did not have insurance before. You know, you want to throw out political theater. The real political theater is that many of us either have a relative or know someone who is addicted to opioids or some kind of drug. They are the indigent people in our community. Yet, we fight against fully funding the high-risk pool, which could help bring them some relief to get some kind of health insurance. I don't understand what possesses this administration to once again change their position and decide to argue that the entire act is unconstitutional. I mean, how many times did President Trump say he supports protections for pre-existing conditions? How many of you in here have a pre-existing condition? Okay, mine is asthma. How many times have my Republican colleagues said it just this weekend? Mick Mulvaney said in a debate about pre-existing condition is over. That's what he said. The debate on pre-existing condition is over. Yet this administration has taken a position that the entire ACA is unconstitutional. 54 times this Republican Congress voted against the ACA. Don't take it from me. I mean, many of your former colleagues, Republican colleagues, you know, went out and straight out lied during their campaign. Orange County is a perfect example where they've lost their election, their re-election, because they lied to their voters, because their voters went to the congressional record and saw how many times over and over and over again they voted against the ACA, but yet they said, oh, we're here to protect the ACA. People are not stupid. Your voters and my voters are not stupid. They get it. They need an affordable health care. We should be working together towards ensuring that we get there, instead of continuing to point fingers. This resolution may not do anything, to ensure that you stop the attacks against the Affordable Care Act, but what it does, once again, we're on record to say to our constituents, we care about this issue. We know that health care is their number one priority. So either you're with us or you're against them. And I'm proud to say and to see that this House is taking this action to defend their health care from those who want to take it away. And with that, Mr. Chairman, I yield back.
Ms. Lesko?
Thank you, Mr. Chairman. If the goal of the Obamacare, which was passed without one Republican voting for it, was to reduce costs, it's a failure, because I can tell you everybody tells me how high their premiums are, how high the deductibles are, and if they have one of these silver plans, they can't afford to pay the, 20–30% plus the deductible. So in this resolution, Mr. Bucshon, it states, part of it is 2B, which says the Department of Justice should cease any and all efforts to destroy Americans' access to affordable health care. Mr. Bucshon, do you think Obamacare is affordable?
No. In short answer, it has not been successful in controlling health care costs as a whole, and which is really the big problem, and then has not been successful in decreasing the amount that, as a whole, that people pay for health insurance coverage. In fact, it's had the opposite effect.
Thank you, Mr. Bucshon, and I would agree. I mean, when I came to Congress and now I'm under the Obamacare exchanges, my premiums have skyrocketed. I have this huge deductible. I think it's a total failure. Thank you. I yield back my time.
Mr. Perlmutter.
Thanks, Mr. Chair. Just my only comment, and to the doctors and to everybody, in the heart and soul of the Affordable Care Act is pre-existing conditions, period, exclamation point. And the efforts by the Republican Party to constantly repeal it, whether here in this legislature or in the courts, is, in my opinion, trying to repeal a civil right that finally the people gained in the Affordable Care Act. And Dr. Bucshon, I know that you'd said this is about pre-existing conditions. If we want to do something about pre-existing conditions, then let's do it. It's in the Affordable Care Act, and until we pass the Affordable Care Act, there were no protections for people with pre-existing conditions.
Under ERISA, there was. I don't think that's not totally true.
Okay.
Under ERISA plans, there were.
All right, I'm not going to debate you on that. You may be right, and I should go back and look. But thank
that
you
didn't
for that.
cover everybody.
Huh? But yeah, not everybody had it. This was
158, 160 million people.
All right. Well, for the rest of the people, this, in effect, said this is a civil right. People don't choose to have pre-existing conditions. You know, whether my daughter with epilepsy or you've probably got a family member or friend, and obviously patients with pre-existing conditions.
Yes, and I agree.
And
it was wrong.
that is the heart of this. And that's why we're going to, you may call it or socialism, or you're worried about Medicare for all or something like that, but I can tell you the Democrats on this panel and across this legislature are going to fight for people who have pre-existing conditions. And we will not give up, no matter what you call it. So with that, I yield back.
Ms. Gannon.
The biggest thing I heard when I was running for office this past year was about health care. I mean, people like the Affordable Care Act in my district. They thought it needed to be improved, but they certainly didn't send me here to shred it and rip it apart. So I'm going to do everything I can to keep it in place for the tens of thousands of people who got coverage for the first time, for the people with pre-existing conditions, for the people like my kids. I've had 2 kids who were able to stay on my health care plan until they turned 26. You know, can we do better? Sure. But I don't see an alternative coming out of this administration, and I didn't see an alternative coming out of the 115th. So I'm going to fight and vote for the Affordable Care Act.
So the American Health Care Act came out of the 115th on the House side.
Mr. Morelli.
Well, I would just simply say that my support for the resolution primarily comes from the Department of Justice's action. As I understand, the Department of Justice is charged primarily with defending the laws of the land, and as last time I checked, the Affordable Care Act, well, not everyone in this body may agree with it. It is the law of the land in the United States, and the Department of Justice has the responsibility of defending laws when they're challenged in the courts, duly enacted by the Congress and the President. The Department of Justice has that responsibility. Its decision to change course suddenly, to no longer defend the law of the land, but to challenge it, leaves open the question that any lawsuits now brought by individuals against the United States and laws duly enacted by the Congress and signed by the President could be challenged by the Department of Justice. It's a terrible precedent to set without regard to how you feel about the Affordable Care Act. The notion that the Department of Justice would turn its back on laws, statutes enacted in the appropriate way by the United States Congress and signed by the President, to me, is just anathema to everything we believe in. So that, to me, aside from the subject matters, the decision by the Department of Justice would lead us to pass this resolution.
Ms. Shalala?
Dr. Bookchin,
Yeah.
can I ask you whether you think the VA is a socialist system?
No, it's not.
And it has,
Just because something is supported by the government doesn't mean it's a socialist system.
even though it's fully supported
The
by the
socialist
government.
system implies there's no viable private sector alternatives to health care. I mean, a socialist system doesn't have viable alternatives, and that's what Medicare for All proposes to do, is take away all the viable competition from the private sector and put that in one place, and that's the U.S. federal government. And in that sense, if you took over the energy sector, it'd be a socialist system also.
So the fact that the administration thinks that we should privatize the VA because they think there actually is competition and another way to do it means that you don't think that it's a socialist system.
Well, the VA, we passed, this Congress, multiple people who have been here passed changes to the law to allow people to go to the private sector from the VA. It had nothing to do with the structure of the VA healthcare. It had everything to do with the fact the VA could not service veterans, specifically in the mental health area, and we had long delays, and we have suicides almost every day of veterans. So adding that private sector option for veterans to access the healthcare system outside of the VA system was just another alternative for people who did not have any other health insurance other than through the VA.
Yeah, thank you. It is true, too, that Medicare, Medicaid, most of the public systems are actually managed by the private sector.
Yeah, I mean, about a third or so of people are on, no, I'm getting to the point, are on Medicare Advantage, which is fully a private sector part of it.
But the rest of Medicare is actually managed by the private sector because the regional organizations manage.
That's correct, and I stated that earlier for Medicaid. That is true.
My point is simply that the private sector is deeply involved, as well as being deeply involved in the Affordable Care Act because it's managing much of the Affordable Care Act. And in my district, I have the largest enrollment in the Affordable Care Act. They do not think it's theater. And by the way, we have never declined, no matter what the costs were, we have never had a decline in the number of people that have signed up for the Affordable Care Act in my district or in my state of Florida, where we haven't even extended Medicaid. There are 1.5 million people that are enrolled in the Affordable Care Act in Florida, 100,000 in my district alone, and my point is that we would disrupt the healthcare system with this effort, this legal campaign to destroy the Affordable Care Act. And it's untenable to me. I yield back.
My colleague, Mr. Woodall, was not here earlier when I made the appointments to subcommittees, but I alert him that he is now my ranking member of the subcommittee.
Is that punishment for being late,
no,
Mr. Chairman? Is that?
No, that's an opportunity for you and I to work together. That's what I'm looking forward to. Do you have any questions of the witnesses?
I do not, but I truly do look forward to working with you.
Absolutely. All right. Larry, I butchered your name so badly the last time until I did. You know, with my name being LC, they called me Alice a lot, so I'm not going to do it this time. Your questions. All right. All right, then. I think we can dismiss this panel. I do want to say to Mr. Bouchon as he leaves that, and to everybody, that when we say Medicare for all, there are several versions of that vision. It's not one version. We have like 88 people running for president on our side, and I guarantee you, you can get 67 versions of Medicare for all, so we need to be mindful of that.
Fair enough, Mr. Chairman.
All right. We'll now bring up our third panel to discuss the Violence Against Women Act. Mr. Klein, we're delighted that you're here. Anything you brought in writing will, without objection, be entered into the record at this point. And I don't think Ms. Jackson-Lee is here, so proceed.
Thank you, Mr. Chairman, members of the committee. Thank you for allowing me to come before you today to talk about H.R. 1585, the Violence Against Women Reauthorization Act. I first want to be clear. I support the goals and intent of the Violence Against Women Act. I think all my colleagues would agree we should work to prevent violent crime, respond to the needs of crime victims, and encourage collaborative approaches among various parts of the justice system and service providers. VAWA generally focuses on domestic violence, sexual assault, dating violence, and stalking, crimes for which the victimization rate is significantly higher for women. We need to combat these crimes, provide resources to law enforcement, ensure victims can access needed services, and overall ensure the critical programs VAWA provides for are working as intended. In fact, my first job out of law school was as an assistant Commonwealth's attorney prosecuting domestic violence cases in Harrisonburg, Virginia, under a grant funded by VAWA dollars. Unfortunately, rather than working together to reauthorize and strengthen the Violence Against Women Act, my colleagues on the other side have chosen to turn this law into a political weapon. It's important to note that Democrats let this program lapse, not Republicans. Democrats refused to include a short-term VAWA extension in the last funding bill. In fact, they specifically excluded it from the bill. Republicans tried to right that wrong by adding an extension to the program through the end of the fiscal year to the February spending bill. Democrats blocked it. We believe there should be bipartisan, bicameral negotiations to reauthorize this important program, but we wanted to ensure the program remained authorized while those negotiations took place. Democrats refused to reauthorize the program and denied opportunities to negotiate in good faith to strengthen the bill. In fact, when Republicans approached committee Democrats about bipartisan negotiations, they refused to discuss anything but their own product, the product that is before us today. That bill was rushed through committee. I will say this, though, at least our committee had a markup. The other 6 committees of jurisdiction weren't even afforded that opportunity. While I support the Violence Against Women Act reauthorization, I cannot support H.R. 1585. It is filled with partisan policy and continues to expand the focus of the law beyond the women it was originally intended to help. The bill adds new and untested alternative justice responses, mediation-like scenarios where a victim and her abuser are placed in the same room, which risks re-victimizing the victim. My colleagues across the aisle will say that participating in alternative justice response is voluntary, and that may be under the letter of the bill, but it ignores the massive power imbalance that often exists between a victim and her abuser. On top of that, these programs that could re-victimize already vulnerable individuals have very little evidence indicating that they work. I would argue that this is not something that we should be willing to take a gamble on. H.R. 1585 curtails prosecutorial discretion and could make it harder to protect victims by conditioning grant funding on the application of policies that discourage the use of bench warrants that are used to compel victim testimony. H.R. 1585 creates new lifetime restrictions for misdemeanor firearms convictions and jeopardizes due process. The bill actually rolls back existing trafficking protections under a grant program intended to help child victims. And these are only a handful of the many concerns with H.R. 1585. As Ranking Member Collins has stated repeatedly, and I appreciate him giving me the opportunity to be here today, Republicans are ready and willing to negotiate a meaningful bipartisan bill that could be signed into law. But I cannot support this bill that has so many concerning provisions that could actually undermine women's safety. The fact we have rushed to consider this flawed bill is particularly disappointing when you consider the fact that this bill will not become law. Rather than continue the charade of moving this bill, I urge my Democratic colleagues to work with us to reauthorize this program in a meaningful way that serves the law's intended purpose and women across America. Thank you, and I yield back.
Thank you very much, Mr. Klein. Mr. Cole?
Chairman, we going to proceed with only one side represented here?
Well, the other side isn't here, and I'm ready to roll.
Well, I'd like to reserve time if the other side bothers to show up for
By all
questions.
means, if you choose, that's perfectly okay, Mr.
If I,
Willis.
well, excuse, may I just submit for the record, though?
Oh, absolutely.
We have a statement from Ms. Wagner, who, I'd like to submit that for the record, then I'll just reserve my time until the other side.
Right,
shows
without
up.
objection.
Thank you very much, Mr. Chairman.
Ms. Torres?
Thank you, Mr. Chairman. I'm pleased that the House is acting to advance the Bipartisan Violence Against Women's Act. We have to act because yesterday and the day before that, and the day before that, someone's daughter was raped, because someone's mother was battered, because someone's daughter was stalked by her ex-boyfriend. And after decades, Republicans and Democrats have come together to say no. This violence is not acceptable. And I hope that we can do that today. And I support this bill, and I'm pleased to offer an amendment to improve rape prevention efforts. And I will yield back.
Thank you. Mr. Woodall?
Mr. Chairman, I did have some questions, but I had them for our Democratic witness. If I
All
could
right,
reserve until she arrives.
Most assuredly.
Thank you.
Right, Mr. Perlmutter? Ms. Scanlon? Mr. Morelli?
I'd only note, Mr. Chairman, as was stated earlier, that Louise Slaughter, who I had the privilege of following, was one of the original authors of this, and I'm incredibly proud to represent the district and to continue that legacy by voting for this bill.
Ms. Shalala?
I support this bill. I worked on the original bill, and I'm very excited to see some of the changes and improvements that we've made here.
Right. Well, I'm Dr. Burgess.
I'll be happy to ask some questions. Now, the current authorization has expired. Is that correct? Is that what you how you testified?
Mr. Chairman, I'd say that's correct.
And but it could have been extended. Sometimes authorizations don't quite get across the finish line, and they are provided extensions. And with everything but the Food and Drug Administration, I believe it would have been possible to extend this authorization. Is that not correct?
Mr. Chairman, that's correct. Often straight extensions enable negotiations of changes to the bill in the future, but straight extensions are often considered.
Can you think of any reason why that there wouldn't be an agreement for a short-term extension at the beginning of this year?
Mr. Chairman, I would hate to try and put motives into the, speak for the motives of leadership, but I would say that it is disappointing that often politics gets in the way of good legislating.
Well, I would agree with it. It's disappointing. I'm not a lawyer, but let me just ask you this. Are there any prosecutors today that are not able to prosecute their cases because this law has not been reauthorized?
Mr. Chairman, I'd say yes, very likely. There are prosecutors out there whose grant funding may have expired, who, without the reauthorization, have been unable to continue, and that those cases have been prosecuted, but they have been consolidated, and other prosecutors have had to take on the load to prosecute those cases.
But the underlying violation of law is not something that's been suspended. If someone is guilty of a crime of domestic violence, for example, it's still prosecuted today, is it not?
Absolutely, Mr. Chairman.
So, well, and again, it's a shame we don't have both sides of the dais represented. When you did your hearings on this bill, was there a discussion about domestic violence loopholes that exist today?
Mr. Chairman, there was enormous amount of effort made to work with the chairman to negotiate in a bipartisan, bicameral way. We were told that this would be the bill before us. The bill before us today was the only bill, and that was the limit to the negotiation that we were given.
So if we were having this discussion a year ago, were there loopholes that prevented the successful prosecution of someone who was accused of a crime of domestic violence?
No, Mr. Chairman.
So as a practical matter, that is that has not changed over the past year's time.
Correct, Mr. Chairman. That has not changed.
This bill, as I understand it, creates a new lifetime prohibition for persons convicted of some misdemeanor offenses in regards to their Second Amendment rights. Did you have a discussion about that in your hearings on this bill?
We did have a discussion on that, Mr. Chairman. I would say that there were concerns raised about the application of such a broad ban in this case, in this legislation.
Because we are talking about someone's constitutional right, guaranteed under the Constitution. Just like the freedom of speech or the freedom to not house soldiers in your home. I mean, this is a fundamental constitutional right.
That's correct, Mr. Chairman.
Well, again, it's a shame we don't have the representation of the other side. Your feeling, your thoughts as those debates at the markup, or I'm sorry, at the hearing stage of this, as those hearings concluded, did you feel that there was correct attention applied to someone's due process before being deprived of a constitutional right?
No, in fact, we were concerned that the markup was rushed, the hearings were done too quickly, and that too little time was given to consideration of the impact of this new law on those due process rights.
So this would not be a fair question to ask you, but I might just offer the opinion that I wonder what is pushing us to react with such dispatch. We know this is going nowhere fast in the United States Senate. We read that in the papers today about all of the good legislation that gets bottled up in the Senate. I'd say welcome to my world. That's where I spent the last 2 years. However, there probably is time for us to try to get this right before bringing the bill to the floor. Would that be a fair statement?
Absolutely, Mr. Chairman.
Will the gentleman yield to me for 1 second?
Yes, of course.
So I understand that our witness hasn't shown up, and I'm not sure whether she will or not tonight. So I think what I'm going to suggest is that, I mean, because I think you want to hear from both sides, and I think we might want to recess this hearing until tomorrow, and we'll work out a time that is agreeable for everybody. And then we'll report out the other two bills, because this bill won't be coming to the floor until Wednesday anyway. But I think...
So there is no rush, reclaiming my time. That answers the question that I posed to
the rush.
That's right, Mr. Chairman.
In fact, we could postpone it to next week,
the rush is
and we wouldn't have really lost ground because the United States Senate is not putting pressure on us.
Well, yeah, but we want to lead by example, so we are going. There is a rush here, but I think if it's agreeable to my colleagues on the minority side, and I apologize that we may have to call.
That's fine.
Call you back, but I think it just for the sake of continuity in the hearing, that may make the most sense. The gentleman from Georgia.
Thank you, Mr. Chairman. You weren't not here for most of Mr. Klein's testimony, but he had some insights that I did not have as a non-committee member. Do we know if the Judiciary Committee will be able to send some Republicans back tomorrow? Mr. Klein going to be able
We'll
to
make sure that
tomorrow?
either the Ranking Member Collins or myself or someone else will be here.
So if that's okay?
Thank you, Mr. Chairman.
So I apologize to you.
That's fine.
But,
Mr. Chairman, if I may, schedule tomorrow for me is going to be pretty tight. There's a lot going on. We got a big markup.
well, if you want to prolong this, you can go ahead, and then we'll go ahead without.
I've gotten my questions answered. I appreciate the
all right.
time, and I'll yield.
All right, but we will try to figure out a time tomorrow to do that, if that's okay. Ms. Lesko?
Thank you, Mr. Chairman. I understand it's obviously inconvenient. I'm always like busy as heck. I'm in 3 committees.
We all are, we all are.
But hopefully I'll be able to attend because I have some, what I think, good things to say.
Well, we will work with you tonight to try to figure out a time tomorrow that makes sense for not only you, but for us as well, because people are on other committees here as well, and we're all busy. But I don't know how else to proceed, given the fact that I think you are owed a witness on our side. So that's the best I can do. Yes, Mr. Hastings.
I ask you consent to include the testimony of the Honorable Johnson.
Without objection.
And the Honorable Grace Ginger.
Thank you. I had offered by unanimous consent a statement from Eddie Bernice Johnson, and now by unanimous consent from Grace Ming, and now from Congresswoman Maxine Waters.
All right, without objection. And so with that, we will recess the hearing on H.R. 1585, and I thank you very much. And we will now proceed to report out a rule on the other two pieces of legislation. So I recognize the, well, we recessed, we're coming back. Yeah. So go ahead. We're doing the roll.
Mr. Chairman?
Yes.
I move the committee grant S.J.Res 7 to direct the removal of the United States Armed Forces from hostilities in the Republic of Yemen that have not been authorized by Congress, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Foreign Affairs. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to commit. Section 2 of the rule provides for consideration of H.Res. 271, condemning the Trump administration's legal campaign to take away America's health care under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule provides all points of order against consideration of the resolution. The rule provides that the resolution shall be considered as read and shall not be subject to a demand for division of the question. Finally, Section 3 of the rule provides that it shall be in order at any time on the legislative day of April 4th to 19 for the Speaker to entertain motions that the House suspend the rules and that the Speaker or her designee shall consult with the minority leader or his designee on the designation of any matter for consideration pursuant to this section.
You heard the motion from the gentleman from Florida. Is there any comment or any discussion or amendment? Being none, the vote is on the motion from the gentleman from Florida. All those in favor say aye. 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 Opposed, no?
No.
In opinion of the chair, the ayes have it.
I'd like to have a roll call, Mr. Chairman.
Roll call has been requested. Clerk will call the roll.
Mr. Hastings.
Aye.
Mr. Hastings, aye. Mrs. Torres. Mrs. Torres, aye. Mr. Perlmutter. Mr. Perlmutter, aye. Mr. Raskin. Mr. Raskin, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Morelli. Mr. Morelli, aye. Ms. Shalala.
Aye.
Ms. Shalala, aye. Mr. DeSaulnier. Mr. DeSaulnier, aye. Mr. Cole. Mr. Cole, no. Mr. Whittle. Mr. Whittle, no. Mr. Burgess. Mr. Burgess, no. Mrs. Lesko. Mrs. Lesko, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
9 yeas, 4 nays.
The motion is agreed to, and I will be carrying this for the majority and for the minority. Mr. Burgess will handle it for the minority. And so the hearing is adjourned.